you very much for coming in and joining us for our hearings. We might begin, if you could each state your name, the role in which you're appearing, and also just confirm that you have received and read the privilege statement and that you agree to abide by the rights and responsibilities set out in that privilege statement. Mr. Shannon.
Thank you very much. My name is Craig Shannon. I'm the CEO of ClubsACT. I have read the statements as you've outlined and certainly agreed to abide by those requirements.
Anthony Ratcliffe, Chief Executive of Eastlake Football Club, and I have also read those statements and agreed to comply.
Great, thank you. We're just going to ask questions and run down the line. I'll start with the first one, which is probably the main one, I think. We've heard from a few sectors. In particular, we heard from retirement homes by Goodwin.
Yep.
We heard from community housing sector.
Yes.
You just heard that.
Yes.
And we heard from the industry about build to rents, and we've heard from you that there is a special case to make that certain types of property development should be exempt from this, or that there should be some type of carve out. We've heard that there are different risk reasons why that might be justified. We've just heard from community housing there's quite a lot of other regulations that apply to them. We heard from the retirement homes that they're owner operators, so if there are defects, they themselves will have to fix them anyway. And they also told us they've never had a defect in the ACT, which certainly sounded very exciting to me. Can you tell me where you see your developments fitting into that picture?
There's a lot of, if I can kick off, I guess, and Anthony might have some more lived experience in some of this to supplement, but there's a lot of crossover between the submissions between ourselves, Goodwin, and the community housing sector. And in large part, that does come from the fact that there are joint developments either in train or being considered by our sector with community housing providers, for instance. In fact, only about 4 or 5 weeks ago, I think the Chief Minister made a public announcement about a project between CHC and the Southern Cross Club, for instance. And as you'd appreciate, as they're joint ventures, to have one party exempted from this sort of outcome and another not would obviously add huge complications into those projects. Yeah. In most cases, because of the diversification agenda, which is outlined in our submission, our members have been looking increasingly at developments in regards to social and affordable housing in the ACT, and that's obviously much to do with the direction of government and the policy objectives that they've got in that area. This now comes as a cut across that process, and it has created a bit of fear, I guess, in terms of our industry in regards to the implications for this. In most cases, our developments are not done for sale, they're done for provision. So to the extent that there might be some small exposure to building for the purposes of selling those properties on, we share a similar situation to the social housing providers to the extent that our clubs would still retain ownership of those properties and still be liable potentially for the rectification costs on their own terms.
So, and I'm sorry about the fear. For me, it's more about the risk for the consumers. Do you will continue to own all of the developments that you develop, or most of the developments?
In most cases, they would be, and I'm sure Anthony might have a view on this as well, but in most cases our members would build for the purposes of retention and would still administer those as affordable or social housing properties. And
what happens with the other ones, the sale, is that...
I'm not personally aware of any that have been done for the purposes of sale or proposed for that purpose, but I'm just not excluding that out of the potentiality. One
last question. So a thing that we heard from Goodwin is that they hadn't had any major structural defects or any rectification orders in any of the retirement homes, and I've tried to test that with other witnesses and nobody can tell me of any defects. We're not really sure if that's the case. Have you got experience in developing, and have you got any kind of track history of whether you've had defects, whether you've had rectification orders?
There has been some, I'm not sure of the extent of it, but there certainly has been some developments in that regard, and I'm not aware of any, in terms of our industry, having exposure to those sort of issues with those properties. And I think I've made the point in the documentation that we see this as a commercially driven problem. We certainly understand the principles of the objectives here, and we have no problem with that. But it is a problem from the commercial side of the industry, I guess, if you want to look at it that way. We do think it's an unintended consequence that the not-for-profit sector and the club industry have been scooped up in regards to addressing that problem. And that's what's brought us to the table, I guess, with our concerns.
I've got to say the market failure seems primarily from developers who have an incentive to make it as cheap as possible, sell it on and walk away.
If there's a profit motive involved, then it makes obvious sense. I would have thought that that's the driver for it. And in the majority, if not nearly all of the cases of our boards and directors, they are not remunerated. There's no pecuniary profit benefit for them in doing dodgy developments, and particularly because most of these are investment opportunities as part of the diversification of club operations, they would retain the properties largely themselves anyway. I think the issue is really driven at the builder certifier level to some extent, I think, in regards to this broader issue. And we don't see that that's got exposure in terms of our members' interests.
Thank you.
Can I start on that, please? So in your answers there, Mr. Shannon, you've focused in on the director's liability provisions.
Yes.
And can I just get a confirmation? You've mentioned that if someone became, so Mr. Ratcliffe, if I became a board member at Eastlake, remuneration for me, is there any?
No.
No, there's none. So the concern is that someone becomes a board member at Eastlake, for argument's sake, and obviously I'm using Eastlake because you're in the room, Mr. Ratcliffe, and I'm not making any assertion about any development that Eastlake might be involved in. But the problem, as you've suggested in the submission, is that someone becomes a board member of Eastlake and is as happy as Larry, and then 2 months later finds out that you're going to be held liable for work that was completed 8 years ago, and you could be fined $320,000. That's the concern, isn't it?
Absolutely.
Yeah, well, that's certainly the advice that we received from our lawyers. We've currently got a property in Kaleen that you're very familiar with, and it's been going on now for some 8 years that we've been trying to go through the development process out there.
Yeah.
We're at a point where we're about to sign an agreement. We've already got an agreement with a developer, but
Yeah.
we're just purely the landowner, and we get captured. The advice is that we get captured as the landowner in this if the bill goes through in its current form.
And the additional fear around that provision is that this bill, in the view of ClubsACT, could inspire more action against developers.
Yes,
Yeah,
absolutely.
that's sufficient for me.
And in fact, there's a lot of evidence that we just heard, obviously, from the previous witnesses that has exactly the same application to our marketplace as it does to the social housing sector.
Thank you. Ms. Orr?
Yes, I just wanted to pick up. We've heard from a few of the other not-for-profits that they've got regulatory schemes already in place at a national level. So the retirement home and aged care living, and also CHC was talking about requirements that they have for registers and so forth. Can you just run me through with ClubsACT whether there's anything in addition to the practices in place in that ACT building system that would apply to the developments you do in the same sort of similar fashion as what we've got for the retirement and aged care and community housing industries?
Well, we're not property developers per se, so we're just purely landowners. With our land is our greatest asset outside of game machines, and obviously, as Mr. Shannon's already pointed out, is that the government's incentive to diversify away from gaming. So we are all now looking at our land assets and how we can utilise them and manage those to derive an income in the future revenue sources. So I suppose to answer the question, no, we're not in a position and we don't have anything in there yet. It may be something we need to look at as an industry in the future. But to be, from our perspective, this came as quite a surprise when we really realised it last month that this bill was being put forward. So for us to respond, it was obviously quite a quick response when we found out about it.
And I think picking up from the point Anthony just made, I mean, in most cases, because of the multi-unit developments involved in a lot of what we're talking about, because the urban infill agendas, we're not talking largely, single dwelling houses, we're often talking about multi-unit developments. And in most cases, because our industry is looking at working in the affordable social housing space, we're talking largely joint ventures with the social housing marketplace to a lot of extents. Our members don't necessarily want to be managing properties or otherwise, and in most cases it's obviously viable to have working relationships with organisations like CHC or Housing Association, Limited, as part of those developments. So it really is that crossover of the joint venture sort of relationships that gives some rigour to what you're asking about, more from the sort of partner side of it than the club side specifically.
So because my takeaway from your submission was the premise was that the not-for-profit sector shouldn't be included in regulation of the private sector. Yeah. So what I'm trying to get to the bottom of and get clear in my mind is the rationale and the justification for that. So, appreciate the others have come in and said, well, we already have all these other regulatory requirements on us. For you, it's a little bit different, as you've just explained, because you're holding the land as opposed to being the developer. So, I guess in a nutshell, can you succinctly say for me what actual custody issues why clubs should not be involved in this scheme? Is it just because you're holding the land, you're not doing the development? Is it because you're not for profit? What are the key points there in your mind that makes you say we should be separate from this bill?
I guess we're probably a slightly more complex and diverse marketplace than nearly all the other providers that you've been talking to. So in that sense, we're talking about in the majority of the circumstances from our industry point of view. So in the majority of our circumstances, they're largely joint ventures with other organisations that do have the rigours that you're talking about in terms of their other obligations. In our sense, it's really about the fact that the not-for-profit nature of our marketplace and the fact that we are trying to achieve government objectives in a range of areas. I mean, clubs are obviously heavily regulated anyway. There's due diligence and a range of other things that apply to them in the conduct of their business activities. And most of the clubs we're talking about would probably be companies limited by guarantee, would be my estimation from what I know of it. So they're probably the larger clubs, if you think of it that way. So they've got certain obligations in terms of their current liabilities as directors under that Act. I'm not aware of any drivers in terms of the profit incentive in our marketplace making this legislation of any benefit necessarily either to the community or otherwise. But if you're asking me if there's any specific nature of regulation to our marketplace in and of itself, then I'd probably say outside of the normal requirements of a club board director, not that I'm aware of.
Thank you.
Mr. Barton.
Thank you, Chair. Gentlemen, the government talks a big talk when it comes to assisting clubs to diversify away from poker machine revenue. And they say they're doing whatever they can to make that easier for you. My question is in two parts. A, do you think that the statements that they make actually are backed up by what's going on in the real world? But B, do you believe that this bill as it stands will be a further impediment to the government's stated aim of diversifying clubs away from poker machine revenue?
Look, with our Kaleen property development, it has been a long and difficult process. We got caught up in the review of the greenfield sites that occurred, which I suppose put possibly an extra 3 years on that territory plan variation we submitted. And then the actual lease variation process was another nearly additional 2 years on top of that. So it has been a lengthy process, and whether it's through the government's fault or EPSDD, I don't know, but it certainly was a long process. And yes, I think it will. It does definitely cause issues. It's very difficult, and that was probably our biggest issue, is that we signed an agreement in 2022 after 8 years of planning, and that could be captured in the legislation as it currently stands. So my directors are already caught, whether they like it or not.
And if I can sort of supplement what Anthony's saying, the biggest single issue that most of our clubs have been dealing with in terms of substantial efforts and investment to move away from poker machine revenue has been in the property development area, as you'd appreciate. And I've got to say, quite frankly, it's been a nightmare dealing with EPSDD in terms of getting either consistent advice, quick processing. We've now raised this with several ministers in the government, and we've had in principle support from both the Minister for Gambling, Shane Rattenbury, and from Mick Gentleman in his previous occupancy of the planning role, that there would be a planning concierge appointed to assist clubs in this sort of processing. That still has not come to play, which is quite frustrating from our point of view, because clubs are, as Anthony explained in a bit of detail than myself, are getting incredibly frustrated, and the cost base of these development proposals over 8 to 10 year periods is incredibly difficult for clubs to manage. And it's a disincentive, frankly, for them to be involved, generally speaking, in this planning space. And then this legislation comes in across the top of that. And I think the starting point of your question, Mr. Parton, was in regards to diversification. There is a substantial acceptance by the government that diversification is best acquitted in terms of planning and development as far as our industry is concerned. And this has been a major problem, and this legislation, as it stands, at best case scenario will delay any expeditious developments in terms of residential developments as the industry's been actually planning and working on. And worst case scenario may stop them altogether. There is no insurance product out there to cover directors in terms of this sort of outcome. As it stands, I think CHC particularly well covered this off. We're concerned that it might take some time before an insurance product would even become available. It may become very expensive. And when a club's got to look at its investment opportunities on a range of fronts, residential housing, it would be bad for the community if residential housing was becoming the least viable investment opportunity for a club to get involved in. Absolutely. Because unfortunately, as it stands, most of our members have real opportunities in terms of land development, in terms of this space. And if there was a disincentive for them to be involved in the residential side of opportunities there because of this legislation, we think it'd be a disaster.
Thank you.
I might supplement on that. You mentioned the planning concierge.
Yes.
Have you raised that with the new planning minister, Steele?
Yes, I met with Mr. Steele 3 weeks ago, I think it was, and certainly raised it in that discussion and said that we'd had previous in-principle commitment from 2 other ministers to achieve this outcome. Apparently it did exist some years ago, and it really was of assistance to the industry in terms of fast-tracking processes through and having a single point of contact to actually help achieve outcomes. But the problem is we get a lot of goodwill in terms of discussions over planning. Unfortunately, and it's the same as the new territory plan process. That was quite torturous as well. And the conflict between zoning and leases is still an issue for us. Unfortunately, there's no quick answers from our side of the fence, and Anthony can certainly explain frustration better than I can. But
yeah, it has been a very frustrating process, and to be able to phone someone within the planning department and get an answer was near impossible.
Yeah, I'm sorry to hear that. I know the issue. I've heard the call, and I wasn't aware it was still an unmet. Yeah, excellent. Look, you've actually covered all of the questions I had written down, so I just want to ask you: is there something else that you think you should tell us before you get up and leave today?
I guess I'll go back to the question Mr. Parton asked. Our concern is that the legislation seems often to be crafted in terms of different silos of perspective and not that broader holistic view of government policy, which we've certainly outlined in our submission. One of the things I'd be concerned about particularly would be that the government might seek to address this issue through regulation rather than through the legislation itself. Because obviously we're talking about long-term investment decision making that takes place, and a regulation obviously doesn't necessarily have the certainty associated with it that the actual bill itself might have. So I know there is some suggestion that maybe regulations might address some of what we're talking about, but we actually think it needs to be in the substantive part of the legislation rather than something that could be varied at some point by sort of a decision of a new company, assembly or otherwise.
Sure, that's an interesting point. It hasn't previously been made. A lot of our other witnesses thought that the problems they were highlighting could be fixed in regulation. And no one had yet raised the long-term implications of that.
I think that is still an exposure risk that we would have to deal with as an industry if there was only a regulation giving the protection.
And is that because of financing? Is that because of investment in the ventures? We have here a system where we've got one house, so making a regulation and changing an act, they're not the same.
That's right.
But they're not too. We're often told they're reasonably similar. You'd rather see it in the act.
Yeah, yes, absolutely, because I think that gives at least some certainty. It's obviously more difficult to change legislation than it is to change a regulation. If a regulation only had the certainty of potentially being in place for the duration of a term of the Assembly, and then the next Assembly might actually get rid of that regulation, we're talking about long-term projects here that can take 8 to 10 years, as Anthony's outlined. If you don't know what the landscape of legislation is going to be over that period of time, then again that becomes a disincentive for a club to leave itself exposed.
Yeah, sure. Thank you.
I'm fine.
That's excellent. Thank you. You've answered our questions eloquently and well. We thank you for your time and enjoy the rest of your afternoon.
Look forward to your report.
Yeah, thank you.